The Supreme Court on Wednesday heard arguments over a law in Mississippi that bans abortions after 15 weeks of pregnancy. The case is putting the future of Roe v. Wade into doubt. CBS News chief legal correspondent Jan Crawford reports.
From across the country, thousands came to make their voices heard. From Michigan,
it's a very serious threat to our ability to shape our futures and our lives.
To this mother and daughter from Pennsylvania.
I pray to God that it's overturned for the sanctity of upholding the sanctity of human life.
Inside the courtroom, liberal justices argued Roe v. Wade was too established to overturn.
There's been 50 years of decisions saying that this is part of our law
and would put at risk the court's legitimacy.
Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
But a majority of the justices appeared inclined to uphold Mississippi's ban on abortions after 15 weeks. Chief Justice John Roberts suggested the court wouldn't have to overturn Roe.
If you think that the issue is one of choice, that women should have a choice to terminate their pregnancy, why would 15 weeks be an inappropriate line?
But that would still be a major retreat from its last big abortion case in 1992, when the court drew that line at viability, around 24 weeks. Mississippi's only abortion clinic, now at the center of the fight, performs abortions up to 16 weeks.
That's the question, is where does the line get drawn? It's them chipping away.
A lawyer from Mississippi said the justices shouldn't be drawing the lines, that the issue should be up to the states, which struck a chord with Justice Brett Kavanaugh.
Why should this court be the arbiter rather than Congress, the state legislatures, state Supreme Courts, the people being able to resolve this?
Now, back in 1992, it seemed almost certain that the court was going to overturn Roe then, but former Justice Kennedy changed his mind and provided that key fifth vote to save it. So that is an important reminder that no matter how things may look today, a lot can change between now and when they hand down the decision, which we expect in June. Lana?
We'll be waiting for that. All right, Jan, thank you. CBS News legal contributor and Loyola Law School professor Jessica Levinson joins me now for more. Jessica, a lot to dig into here. What do you think were some of the biggest takeaways from Wednesday's hearing?
I think the biggest takeaway in having a few hours to reflect on it now is that the court is poised to overturn Roe v. Wade. I think the question this morning really was, is the court going to find some sort of middle ground where they say some version of, we're upholding the essential promise of Roe. You still have a constitutional right to obtain an abortion. It's just much narrower than you thought it was. After really listening to the arguments and thinking about it, I don't think that's where the court goes. I think this court just says we are overturning Roe versus Wade. It was wrongly decided, in part because this is the most conservative court we've had since the 1930s, and they don't need the Chief Justice to make a decision. The conservatives have those 5 other votes.
I was going to ask you about what we heard from Chief Justice Roberts, but I think you make the point that even if he were to join the more liberal justices, that they would still have it on the conservative side to potentially overturn Roe versus Wade. What type of historical precedent exists for the court to overrule its previous decisions, especially on something that's been so debated, something that I imagine every justice has been asked during their confirmation hearings, to which, the standard line has always been, it's the law of the land. So how much historical precedent exists on this, Jessica?
It's interesting that this is a case that's going to be about abortion. It's also going to be about stare decisis. It will be about when the court actually respects its prior case law. And so, as the conservatives mentioned, there is, in fact, precedent for overturning cases when they say those cases were wrongly decided. And they pointed to, for instance, their decision that separate is equal, separate but equal, which they, of course, overturned in Brown versus Board of Education. I think a lot of people kind of stiffened when they heard Roe compared to the doctrine of separate but equal, which was, of course, rightly overturned. There's also other case law dealing with same-sex marriage or gay rights, where the court overturned its prior case law, and even in Money and Politics and Citizens United. But those tend to be the decisions that are fewer and farther between because of that doctrine of stare decisis, because of what Justice Sonia Sotomayor was talking about, which is, doesn't it have to look like people can rely on our decisions?
You know, what's interesting, Jessica, though, when you're talking about those historical precedences, they coincided with public opinion changing and moving more towards an acceptance of that separate is not equal, that gay marriage should be allowed for equality reasons. But CBS News polling shows that 62% of surveyed Americans think that the Supreme Court should leave Roe versus Wade as it is, and 47% think that overturning it would be a step backwards for women. Is public will something that the justices are likely to consider in their final decision at all?
Some of them will. I mean, you heard Justice Sonia Sotomayor, the first thing she said for my time, 7 a.m. this morning, you heard her say, will this court ever get the stench off if it makes a decision to overrule Roe? And then I think you have 5 justices who frankly are not concerned about that, who think that Roe is wrongly decided, it shouldn't have been part of the Constitution, and it's their role as judges to right that wrong. So if you have 5 justices who really aren't concerned with popular opinion, which in some cases they should not be, then no, it's not going to make a difference.
Jessica, you've said that there are 3 possible scenarios for when the justices issue their ruling next summer. Break those down for us.
So the scenarios are basically, one, that they do nothing. They say, we shouldn't have taken this case. We wish we didn't open this can of worms. I think that's just not going to happen given what we saw this morning with oral arguments. The second path is basically the one that I think Chief Justice John Roberts wanted, which is, well, let's uphold Roe and Casey, but just say it's much smaller than we thought it was. It would allow this 15-week abortion ban. And then the third route here is, I think, the one that the court takes, where they say, you know what, Roe and Casey were wrongly decided. It doesn't say it anywhere in the Constitution. It's up to the states and if Congress, if they want, to make a different decision. But we're not going to uphold this 40-year-old precedent.
All right, Jessica Levinson, thank you.
Thank you.